Hey gang, Stephen Marshall, KY at landlordlaw.com. Hope you had a fantastic Labor Day weekend. Back with another update because when we last spoke, there was some tremendous uncertainty out there. And I'm glad to say that some of that has been cleared up, at least momentarily. So here's an update on where things stand as of today. And please realize this is really as of today. Things can always change. But the good news is I don't expect a lot of change going forward like we've seen in the last 2 weeks. In the last 2 weeks, we've seen new orders twice in each of the last new weeks that have kind of shaken things up. I don't expect that type of volatility going forward. So hopefully things will be stabilized at least for a bit. But here's where we are today. So last week, Friday, September the 4th, the CDC regulation took effect. And it prohibits evictions based on non-payment of rent or fees through December 31st of this year for any tenant who declares 5 things under penalty of perjury. And here they are, just as a review. The tenant has to certify that they have used their best efforts to obtain all government assistance for rent or housing. And stay tuned towards the end of this video because I've got an update on some state assistance for landlords and tenants. But that's the first thing. They have to certify that they've used their best efforts to get all available assistance for rent or housing. Second, they have to certify that they expect to earn no more than $99,000 in 2020, or that they weren't required to report any income in 2019 to the IRS, or that they received a stimulus payment. That's requirement number 2. Requirement number 3, they have to certify that they are unable to pay the full rent or make a full housing payment because they lost their job, that they had a significant loss of household income, they lost hours at work, or they incurred extraordinary out-of-pocket medical expenses. So that's requirement number 3. Requirement number 4, they have to certify that they're using their best efforts to make timely partial payments that are as close to the full payment as possible. And then the last thing, they have to certify that an eviction would likely render them homeless or forced to live in a shared living situation, such as with a family or friend or in a shelter. So those are the 5 things. And the CDC has created a declaration form that tenants may use to make this declaration. If you're on my email list, I sent a form to you guys late last week so that you would have one in your hands. Since that time, the CDC has created an official form. And I'm going to link that on my website. I actually like their form better than mine. It's a little briefer. It's probably not as thorough, but it's a little briefer. So I'm going to link that on my site, and we'll link it in this post. So if you're just watching the video, make sure you go to the actual blog post to get the link. So that was the first thing. Then late Friday evening, the governor issued a new executive order in which he adopted the CDC regulation for the state of Kentucky. So not only do you have the CDC taking their action, you have the governor making it specifically applicable to the entire state. Now, interestingly, and some good news is that his new order rescinded his August 24th order, or at least parts of it. Sections 1 through 4 have been rescinded. And what that means is that landlords are no longer required by the governor to give 30-day notices or to attempt to meet and confer with their tenants. Okay, so that's something new. In addition, you're no longer prohibited by the governor from charging late fees, penalty, or interest on unpaid rent. If you remember, that August 24th order prohibited the charging of late fees, interest, or penalties from March 6th through the end of the year. That has been rescinded by the governor, and I'm going to link his new order in the post. So, where do we go from here? Let's take a look. What about evictions filed prior to September 4th for non-payment of rent? Okay, here's where I've gotten some clarity this week based on a few days in court. Judges are granting judgments against tenants who fail to appear in court, even for non-payment of rent. However, if your tenant appears in court, what's been happening so far is that they are being given 2 weeks to review the CDC declaration form. And then they'll come back in 2 weeks. If they've signed the form by then, the case will not move forward. It'll just be continued generally until further orders of the court or until the CDC regulation is overturned or rescinded or it expires. If the tenant doesn't sign the CDC declaration form, then the case will be heard 2 weeks later. So that's kind of the status of these evictions that were filed prior to the CDC order. The questions I'm getting: should I continue to give notices to pay or vacate? Yes. Listen very carefully to this. Non-CARES Act properties, you're going to go back to giving your usual non-payment notices. For many of you, if not most of you, that's a 7-day notice to pay or vacate. However, we're still under a Supreme Court order from August the 28th that requires 30-day notices from CARES Act properties. Okay? So non-CARES Act properties, you're back to your usual notice now. CARES Act properties, you're still giving your 30-day notice. Again, that's not based on the CARES Act itself. It's based on a Kentucky Supreme Court order that applies statewide that requires 30-day notices to evict from CARES Act properties. Now, I have no idea why this was included in the Supreme Court order because the CARES Act is expired. I wouldn't think you should still be giving 30-day notices, but that's what the Kentucky Supreme Court has ordered, and I will link their order in the post that accompanies this. Another question I'm getting: do I have a duty to provide tenants with the CDC declaration form? I'll be very clear. No, you're not required to do that, but I think you should. And the reason is that tenants who show up in court are being given additional time to review and sign the CDC declaration form. If they do sign the form, the case cannot move forward. So, providing that form up front may allow you to avoid filing a fruitless eviction. Okay? Tenants can see the form, they can sign it, you know not to file against those tenants. Now, if they don't sign the form, you can move forward. But you need to understand that if they do show up later and sign the form, the eviction probably won't move forward. So, whether you provide the form or not, that's your call. My advice is to do it, but that's a strategic call, and that certainly is up to you. Both the Supreme Court and the governor and even the CDC have emphasized in their orders that your tenants still have a duty to pay rent. So make sure you emphasize that in your notices so that there's no lack of clarity from your tenants that, yes, they still have a duty to pay rent, whether the ability to evict is in place or not. Next question: what if my tenant refuses to complete the declaration form? Well, then they are not a covered person under the CDC regulation, and you may proceed with an eviction. The problem is that the CDC regulation doesn't provide a time frame for the tenant to sign the declaration. So it's entirely possible that you could give your notice and provide the declaration. The notice expires, you file your eviction, you get your court date, and the tenant shows up and says, hey, what is this declaration form I'm supposed to sign? And the court gives him 2 weeks to sign the form, and then he signs it, and your case doesn't get to go forward. So that's entirely possible. But ultimately, if the tenant doesn't complete the declaration form, then your case can move forward. The way the CDC regulation reads is that every adult in the rental unit needs to sign a form. Okay? Now, if you get one person in the unit out of 2 or out of 3 or out of 4 who signs it and the others don't, should you move forward with the eviction? Again, that's your call, but ultimately, if you can get rid of only 1 or 2, but you can't get rid of the others, that doesn't help you much because that doesn't get your unit back to you. So, yes, you certainly want everyone in the unit to fill out a form, but if any one of them fills it out, I don't think your case will be allowed to go forward. So, do with that what you will. Another popular question: what if my tenant puts inaccurate information on the declaration? May I evict them in that case? Well, possibly. The new CDC regulation is not clear on that point. Under the language of the regulation, providing false information on the declaration form is a federal crime. Okay, it's a federal perjury charge, not a state charge. As a result, the remedy is a criminal action, a criminal complaint filed against them, probably by the U.S. Attorney's Office. If the tenant is convicted of perjury or some related offense, you'd certainly be able to evict in that case. The problem is that I'm skeptical that federal prosecutors are going to take action on those types of cases. I hope that I'm wrong, but I don't see it at this point. But I hope I'm wrong. Still, even if there's not a prosecution for perjury, if you can show a judge that the tenant provided false information, I think you could proceed with an eviction. The problem is going to be that proving that is going to be very difficult because as you can see, those 5 requirements that they have to certify and declare, they're somewhat subjective. Okay? The tenant has to say that they've used their best efforts. Well, it's hard for a landlord to prove that a tenant hasn't used best efforts. It's always hard to prove a negative. And it's definitely hard to prove a subjective negative, best efforts. What does that mean? So if you could prove it, yes, I think your case could go forward because the tenant wouldn't be covered by the CDC reg, but that's going to be very, very difficult. But if you think you have that type of case, please reach out to me and we'll talk. Things to remember, again, the CDC reg only applies to non-payment of rent cases. You may still go forward with evictions for criminal activity, for health and safety violations, for damaging the unit, for violating any codes that are out there, or violating any other material lease violation, okay, or any other material lease obligation. You can still move forward for those. I addressed the non-renewal issue in my last post. If you haven't seen that, please go back and take a look at it. I expect this week that the National Apartment Association is going to file a lawsuit challenging the CDC regulation. If that happens, I'll certainly let you know and we'll keep you updated on the progress of that suit. And then don't forget, starting September 21st, eviction cases in which a tenant actually shows up to court will automatically be continued for at least 2 weeks in order for both parties to seek rental assistance. That starts September 21st. I think that's a drop-dead start date. It's not just for cases filed on or after that date. It's for cases that are in the system that have a court hearing starting September 21st or after. So you appear in court once. It's continued for a week if the tenant, or 2 weeks if the tenant shows up, and then it'll be heard at that second court date at least 2 weeks later if the matter hasn't been resolved by that point. All right, and then the last thing I wanted to talk about is that today the state unveiled its website that allows landlords and tenants to apply for state funds for eviction relief. Okay, I'm going to link the website in the post here. But I will tell you that there are strings attached. As a landlord, in order to apply for this rental assistance, you must agree to forgive up to 10% of the rent due and forgive late fees, penalties, and interest related to non-payment of rent. Okay, that's requirement number 1. Requirement number 2 that you have to agree to is that you have to agree to give 45 days notice for any future eviction, not to be initiated until at least 30 days after the assistance ends. Okay, so when you go to the website to apply for assistance, you're going to have to agree to those 2 terms, to forgive up to 10% of rent that's due and forgive all the late fees, penalties, and interest. And then you're also going to have to agree to give 45 days notice for any future eviction, which cannot begin until at least 30 days after assistance concludes. So as you can kind of figure out here, the goal is to keep people in their housing. That's the reason that this money is going to go out. I don't think you'll be able to get money for tenants who are already gone who owe you back rent. But feel free to go to the website, check it out for yourself, and encourage your tenants to do so. Okay? Encourage them to go get money so that they can pay their rent to you. Just everyone needs to realize that there are strings attached to this money, as is often the case. And then the last thing before I go today, I know a lot of you ask me questions on social media, and I have tried my best in the past to answer those, especially for my clients. You guys have paid me and you work with me, and we have a great relationship. And so I try to answer those questions on social media when I can. But I'm getting overrun with those questions from a lot of different angles. So I'm trying to get things under control so that I can address questions a little more thoroughly. A lot of times I read these social media comments. I'm at a ball game, or I'm at the gym, or I'm doing something where my mind's going a lot of different directions, and the questions are coming from a lot of different directions. So I'm going to try not to comment, to answer any questions on social media. If you got a question, shoot me an email, smarshall@tripleslaw.com. That's TRIPLESLAW.com. And so please don't be offended if I don't answer your question on social media. That's going to be my policy going forward, that I don't answer those questions. It's just too hard for me to type on my phone to keep up with all the different comments. So just shoot me an email and I will certainly get your question, of course, for a small fee. So again, a ton going on over the last couple of weeks. The good news is I expect things to stabilize. I'm told as of Friday afternoon, the Supreme Court is not going to issue a new order on evictions anytime soon, or addressing the CDC regulation. So I'm hopeful that things are going to stabilize, other than the National Apartment Association lawsuit, which we hope gets filed this week. So that's it for now. Hope you're doing well. I'm sure we'll talk soon. Have a great week.